Be ready. 5 seconds. Start. Now we may deal with another aspect of this very facet of the case. It is a very pertinent issue as to what the role of the state should be after the affiliation is granted by the affiliating body. We have already discussed that the state opinion as contemplated under Section 37 of the University Act, to the extent it admits to overreach, is reconcilable, and its results are not in its orientation to the directives of NCTE are void and inoperative to the extent they can be resolved, in which case clear precedence is to be given to the directives of NCTE during such resolution. The opinion of the state, therefore, has to be read and construed to mean that it would keep the factors determined by NCTE intact and then examine the matter of grant of affiliation. The role of the state government is minimized at this stage, which, in fact, is a second stage. It should primarily be for the university to determine the grant or refusal of affiliation, and role of the state should be the bare minimum, non-interfering and non-infringing. It is on record, and the regulations framed under the Act clearly show that upon receiving an application for recommendation, NCTE shall send a copy of the application with its letter inviting recommendations or comments of the state government on all aspects within a period of 30 days. To such application, the state is expected to respond with its complete comments within a period of 60 days. In other words, the opinion of the state on all matters that may concern it in any of the specified fields is called for. This is the stage where the state and its department should play a vital role. They must take all precautions to offer proper comments supported by due reasoning. Once these comments are sent and the state government gives its opinion, which is considered by NCTE and examined in conjunction with the report of the experts, it may grant or refuse recognition. Once it grants recognition, then such grant attains supremacy vis-a-vis the state government as well as the affiliating body. Normally, these questions cannot be re-agitated at the time of grant of affiliation. Once the university conducts inspection in terms of its statutes or act without offending the provisions of the act and conditions of recognition, then the opinion of the state government at the second stage is a mere formality unless there was a drastic and unacceptable mistake or the entire process was vitiated by fraud or there was patently imminent danger to the life of the students working in the school because of non-compliance with a substantive condition imposed by either of the bodies. In the normal circumstances, the role of the state is a very formal one, and the state is not expected to obstruct the commencement of admission process and academic courses once recognition is granted and affiliation is found to be acceptable.